She's a beauty. She's game. So I forgot to tell you one thing. We do, from the Hemp Embassy, we do a weekly, it's called Hemp Embassy Headlines, a weekly mail out of what's happening globally with cannabis. It's just a free thing. If anyone's interested, you sign up for that. Out there where they're selling the books, there's a form. Just put your email address down there. It's worth getting, and then you'll always know if these events are on or anything that's happening as well. Now I want to introduce you to Sally McPherson. Where is she? I hope she's here. And I only met Sal the last few years, and she's a beauty. And we always need lawyers, and I'm finding, you know, lawyers are making a lot of money out of prohibition, so it's nice to find lawyers who want to end it. They're rare. Anyway, Sally, Steve Bolt often talks at this, and he's away, and Sally's working out of Lennox Head.
Yeah.
And great to have you here, Sally.
Thank you very much.
I'll do it.
Thank you.
So we can please tell the audience your surname. Sure.
Hi everyone, I'm Sally McPherson, and yes, solicitor, yes, lots of lawyers are making a truckload of money out of the war on drugs. Not all of us, some of us actually take issue with what's going on in the community. Steve Bolt, phenomenal lawyer, he's had a lot of success in what, well, I'll get to it, but Steve's had a lot of success in what we call honest and reasonable mistake of fact defence. Yes, I'm at risk of boring you all to tears, but and I have a particular interest more in sort of medicinal cannabis and defences and how people are travelling with particularly lawfully prescribed users, but also people who aren't lawfully prescribed but who just know it's doing them the world of good. So that's sort of my particular interest in it. As I said, the risk really is me probably boring you to tears, and I'd like not to do that, but it is a rave about the law and what's going on. So I've thought of a couple of topics. If there's something you want to ask me, please do. And if you feel like I'm rambling and getting really dull, please just...
We love lawyers.
Oh, yeah, everyone loves lawyers. Can't get enough of them. So I thought I'd just do a bit of a general discussion about some of the kind of current issues around us all, the community we're living in. And I sort of broke it down into a couple of areas. Firstly, to talk about mainly driving and the MDT regime, or mobile drug testing, or random drug testing, whatever you prefer to call it. I tend to call it MDT as opposed to RBT, just to separate it. And a couple of things with that really was to talk to you about what's worked in the courts in terms of defending yourself against a charge for driving with a trace of cannabis in an oral fluid sample. Let me just start by saying I hate the expression drug driving because it implies that the person was out of it, when we all know that that particular offence, you're not out of it, you're not impaired at all. In fact, there's not even an argument you're impaired, because if you were impaired, you'd be charged for something else. You'd be charged with driving under the influence of a drug, right? It's a whole separate charge. This charge is driving with a trace of cannabis or a drug. They're testing all the amphetamine family, cocaine and pot. So just driving with a trace of it in an oral fluid sample, and it's detectable at 5 nanograms, and 1 nanogram is 1,000 millionths or 1,000 billionths of a gram. It's something that outrageous, and that's why it's picking up people days later. But that's what the side-of-the-road tests are testing for, and the prosecution's kicking in at about 10 nanograms per gram. So 10 1,000ths of a million per gram. So I guess the issues there are, you know, what can we do? I don't know if any of you are aware, we've had a few successes, particularly in Lismore. We seem to be travelling really well around the state, given that we've got the highest drug testing regime, mobile drug testing regime going on in the state. We've also had some spectacular successes, particularly Steve Bolt, and particularly in the Lismore local court, and one in particular in the Lismore District Court. We're quite setting a good example for the rest of the state. One of the recent ones that I was asked about quite a lot is the passive smoking defence. Has anyone heard that there was a recent success with what's colloquially being called the passive smoking defence? Yeah? So I'll just call her Nicole, because we don't need to continue to publicise her name, but Nicole gave up smoking weed on the 1st of January.
Sorry, I just have to... I'm very interested in this. So is there a court case that you can refer to, like someone versus someone on such a date that you can perhaps
I'm
tell
just
us?
doing, yeah, that's Nicole's case. So she stopped smoking weed on the 1st of January. It was a New Year's resolution. She got pulled over on the 16th of January. And she'd been a carer for a terminally ill neighbour who smoked weed incessantly, all the time, but she'd completely given up, been 16 days from her last ingestion of any cannabis. So she went along to court and pled honest and reasonable mistake of fact. I didn't think for a second that I'd have cannabis in an oral fluid sample. So this was, again, Lismore Court, Steve Bolt's case. If there's one thing I'd like you to take away from today, if there's just one thing to take away, that is, it all comes down to the circumstances of you, the circumstances of committing the offence, the context of the offending, the backdrop to it. It's really important to understand that these defences are very circumstantial, okay? So passive smoking, in short, it's not really a defence, okay? Sorry, but I was at a friend's place last night and everyone was smoking weed. That's not really a defence, okay? Having said that, it did work for Nicole but in that instance, kind of a couple of things came to the fore. She was able to say, look, it was an honest mistake and it was reasonably held for the following reasons. 1, I don't smoke weed anymore. 2, I asked a police officer, remember, so this is her circumstance, I asked a police officer if you could return a positive result to a mobile drug test if you'd been around, passively smoking, and the police officer told me no. So I relied on that. And I also did check into the government website. There's that road safety website that says 12 to 24 hours. I read the government website and it said 12 to 24 hours and it didn't mention anything about passive smoking. So it was on the basis of those particular circumstances, and adding to that, importantly, she was seriously scrutinised in the witness box. Okay, the prosecution did not let up in cross-examining her, which is that real kind of nail-biting, I put it to you that you did this, and I put it to you that you're lying about this. So she was fully scrutinised by the prosecution. And the magistrate said, look, you're a really honest person. I can see that you've given your evidence uncontroversially, it's been consistent all the way through. I believe you, you're a credible witness. I believe you haven't been smoking pot for those preceding 16 days. And all things considered, you did form that belief quite reasonably. So she was found not guilty of that charge. So you can see very much circumstantial. Okay, came down to that set of circumstances. There's another guy, I won't keep banging on about cases, but I do, like I say, I want you to take away from this, it comes down to my circumstance, which is why I probably do need a lawyer to see what they think about my circumstance. But there's another guy who got pulled over in May 17, Jason Cottrell, another Steve Bolt case before the Lismore local court. Pulled over in May, positive result to the drug test. Of course, his number plate goes into the automatic number plate recognition system of the police, as so many do, so he gets pulled over a month later in the June. Well, when he'd been pulled over in May, he said to the officer, look, how long should I have waited? I haven't had a joint in a while, but how long should I have waited? And the police officer said, 7 days. You should be right after 7 days. So when Mr Cottrell got pulled over a month later by the same police officer, I believe it was, he said, I haven't had a joint for 9 days. It's been 9 days, you told me 7. So he went along to the court and said to the court, well, I'm pleading guilty to the first one in May, but not guilty to the second one, because I formed this belief that I'd be okay based on my conversation with the police officer. And the court said, fair enough, that was an honest mistake, reasonably held. That's the two elements of it. It's a genuine, honest mistake, and it was quite reasonably held how he came at that decision or belief. I won't keep going on. There's another one that came out of the Lismore District Court. The great thing about that is that they tend to be binding precedent on lower courts, but I won't bang on too much about that. But suffice to say again...
Actually, we like hearing these court cases.
Do you?
Yeah.
Do you? Oh, okay. Well, there was another one in the Lismore District Court, and now in that instance, it was a woman who had explained to the court that she left school in Year 8. She could read and write, but to a limited ability. And so what she was sort of saying was my sort of research skills are pretty limited. But what had happened was she'd come to the attention of police at some stage and been issued with that 24-hour side of the road suspension. You know, if you if you get a positive result. So with that in mind, she got a positive result, and she said, okay, well, yeah, I did. I smoke a joint most nights before bed, so fair enough. It's lunchtime the next day, okay. So she went about her business. However, she came to the attention of police, sometime later, and she said to the police, this isn't fair because I understood that it was a 24-hour suspension. So based on that, I believed it would have been out of my system within 24 hours. Well, I didn't smoke a joint last night. In fact, it was the night before. So it's been more like 36 hours. So that's how she formed her belief of the situation. Now, again, she was able to demonstrate that she wasn't great at reading and writing and education, and she come from a fairly disadvantaged background, and she said, but that's how I formed my belief. Well, the prosecution were like, well, you should have added up the 24 hours plus the time last, it doesn't matter. But suffice to say, that was a district court decision of Judge Laura Wells in Lismore, and she succeeded on that defence in that set of circumstances. So sometimes having too much information can kind of work against you because, well, for a start, this isn't legal advice, this whole talk today, but you're actually now sort of getting some information that wouldn't assist you in an honest and reasonable mistake of fact, because what you're taking away from this is, oh wait, it's really circumstantial. And secondly, the credibility of the witness is really important, being the accused witness is really important, and how the judge or magistrate sees them and assesses that credibility, so that's critical. The other available, so that's sort of MDT, one defence, honest and reasonable mistake of fact. The only other available defence, and I really would bore you to tears if I told you why, but just trust me, the only other available defence is necessity. Okay, so on the one hand, honest and reasonable mistake of fact, I just gave you 3 examples of that. If you were to draw it, on the other side of the tree diagram would be necessity. And this really is where the medical cannabis cases come to the fore. Okay. So I've acted for a lot of people who have been charged with various cultivate offences, a lot of them for personal use, demonstrated medical evidence of how, for pain management, how they were ingesting cannabis for pain management, and had incredible success actually with that, pleading guilty but showing some mitigating features of the offending. So yes, he was growing 5 plants, yes, but here's what he was doing with the 5 plants, and here's some evidence of how long those conditions had existed. Here's some evidence of the meds he used to be on, and here's some evidence of how few meds he's now on, and why he was using cannabis medicinally, even without a script. And again, I've got to say credit to our local magistrates. That was, generally speaking, our local magistrates, our regular sitting ones in Lismore, the Ballina Circuit, and then Tweed, they're pretty good and pretty reasonable people. One of them is, who's here today, is Morgan Taylor, and I had the privilege of working on that matter with Morgan's family. Are you familiar with Steve Taylor's matter? No? Okay, Morgan, you can probably tell the story better, but... Okay. Steve Taylor, Morgan's father, was growing plants in Sydney for one purpose, and that was to juice the whole plant, juice the leaves, for ingestion by his 2 daughters, particularly Morgan, who had chronic symptoms from Crohn's disease. And the litany of medication she'd been on is, I get goosebumps just using that expression, about the litany of meds she'd been on. It was appalling, the side effects and the possible long-term side effects. So her father was just growing weed in the backyard and juicing it. You all know you can't get stoned off juiced cannabis leaves, right? No matter how many kilos of them you have, you can't. So they raided, seized all the plants and charged Steve. So this, I say that story because, and similarly Tony Bauer, who you may know, was growing to support, assist in the production of medical cannabis. But I say that story because this is an example where necessity might have worked as a defence in Steve Taylor's case. We didn't, in the end, go with that for a host of reasons, but strictly from the lawyer's perspective, not the family's perspective of how gruelling the hearing would have been, but from the lawyer's perspective, just to give you an idea of why lawyers tend to kind of shy away from this defence. This is the reasons why, and I promise I won't get any more boring about the law than this, but here's the 3 things that you need to establish to plead the defence of necessity, okay? The first is that, so 3 tests, 3 elements of the test. The first is that you committed the offence to avoid a circumstance of irreparable evil. Right? So this is where sort of you're obviously going to be facing a prosecution who's going to say, well, there are pharmaceuticals available, so you did have the choice. You just made a choice to take something that was illegal instead of lawful and prescribed. But so irreparable evil, right? That's pretty full on. That's straight out of the case, right? Secondly, is the reason that you committed the offence that you're saying was under necessity. Secondly, is the belief that you're in a situation of imminent peril, right? Which you can see is hard when you've got somebody who's got a condition that has been treated with pharmaceuticals. Putting aside the awfulness of the side effects that they're suffering from and could well into the future, like really have lifelong consequences, some of the meds that Morgan was on. And thirdly is that you only did something, the offending conduct was only in proportion necessary to avoid the peril. Okay? So, you know, the necessity defence, we call it medical necessity colloquially, it's really just a necessity defence, but in this case we'd be arguing on medical grounds would be the necessity, but it sort of has come to play in situations where maybe you're in a really particularly remote regional area, somebody's having an appendicitis right in front of you, you're 12-year-old, and you go, I know I've had a couple of drinks, but get in the car. You know, that kind of thing. So you can see there's, you know, you can sort of fit into these tests of avoiding imminent evil, the imminent peril of the situation, and that you did something in proportion to that peril. But it's much harder with people who are using medicinal cannabis where there's pharmaceutical options. And this is where we're really coming, you know, it's waiting to be tested. There's got to be a lot of tests at court done because we need at some stage those 3 elements that I just spelt out. That comes from the Supreme Court. Now, none of the lower courts can do anything about that. We're all stuck with it in the local court and the district court. We're stuck with what the Supreme Court said you have to establish in order to establish the defence of necessity. So we're stuck with it. So until some matters filter through the system to the Supreme Court, so if we were to take it, just to give you an example, if Steve Taylor's matter had been run not guilty on the basis of necessity, daughter's sickness, it all falls right into the definition, so it's to avoid your own harm or somebody who you care for. And really, in the perfect world, we probably would have needed to lose in the lower court to appeal it to the district court, to get it up to the Supreme Court, to get the tests changed. So it's a hugely gruelling process to put people through who just want to ingest medical cannabis for medicinal grounds. Sometimes it's pain management, sometimes it's to get to sleep, sometimes it's to relieve anxiety. We all know, like, you know, it doesn't have to be the only choice for it to be the good choice, you know. Look, that's my kind of the things I wanted to say about what's available to you for the, if you are caught in the gambit, the net of mobile drug testing. The 2 defences available to you are honest and reasonable mistake of fact. We've had some successes with that, very much circumstantial. Necessity is the other one, again, very much circumstantial, and you've got to have some real grit if you're going to want to take it as far as it probably needs to go before we can get some seriously good law change in Australia. If there's any more questions on this, please ask.
Yes. I'm dying to ask you a question, and it may seem silly, But the question is like this. Just briefly and two parts. Is there a place where civilians can go to actually read court cases on cannabis trials, like a library, or are there books to referral to? And then the second question is, and this is a bit aloof, I suppose, and not relevant, but here it is. Someone told me that there was a High Court person in Australia, a judge, in about the 60s or 70s, and the name was given, and I checked it up, and basically it's true. He said something to the effects of, if a law is unjust in Australia, you have a right to disobey it. I forget this High Court person, you may have heard it about in your studies. But the point is, it touches on what you're saying, and as a layperson, do I have a right to disobey an unjust law if I see it as such? And can I build up a body of cases and outcomes by referring to a library of cases?
To answer your first question, local court decisions aren't reported because they don't bind any other court. They're purely persuasive. And in my case, the only reason I have those decisions that I've spoke about today are because I've asked someone to get a copy of the decision, and that includes the district court matter. So no, there isn't a one-stop shop where you can go to, because I mean the magistrates court, the local courts in New South Wales handle something like 95 or 96% of all criminal matters in New South Wales are dealt with and finalised in local court. There's very few matters that go through the district courts. They're very, serious offences. And then that go up to the Supreme Court. So no, there isn't ready access to a library or a database of local court decisions about what we're talking about today, but I'm more than happy to give anybody copies, putting aside copyright infringement. I'm more than happy to, give you some copies of what I've got. In answer to your question about civil disobedience, well, in short, I don't know, but challenging it has to be within the context and the framework of the existing regime of law. Would be my I don't know, but that's my gut reaction answer. Now, I'm not saying if it was Mason or whoever it was, Chief Judge Mason, who said that is wrong, obviously, far be it from me, but I think you'll find that in terms of challenging the law that's unfair, inherently unfair or unjust, it's got to still be within the matrix of existing law, because there's really no end to what one person would say, well, that's just not fair, I should be allowed to hit her because she was rude to me or something.
Yeah, but I'm going to say I was in pain to the judge, and that's why I use my cannabis. And
so you'd probably be, therefore, within the framework of the law, you'd be saying necessity. Yeah.
And then I'll be shot down as a failure because the judge just says, well...
But you may be shot down in a failure because you say, look, I'm anxious, Valiums don't agree with me, so it helps me get to sleep, it calms my anxiety. You go before a local court, they'll say, irreparable evil? Nah. Imminent peril? Sorry. Yeah. So you listen and take it to the next step. The district court, they'll probably do the same thing, but you'd be going to the Supreme Court saying, this is just manifestly unjust. You can't apply this strict three-element test of necessity to medical cannabis. And then that would form the basis of your plea in trying to change the test at a level of the court where they can change it.
I don't want to hog the mic or anything, but I just want to say that journey is very expensive. Trying to defend yourself all the way up, it's impossible.
That's exactly right. It is. It is, outrageously. And you need to get the right case to do it. As a lawyer, I can tell you that some cases are the right ones to run all the way up the flagpole and get it to the Supreme Court level. And you get a lot of community support, I suspect, in that. I do my share of pro bono in those sort of issues.
Please repeat the questions so we can all hear.
Yeah.
Go.
Oh, sorry. I just want to know, how hard are you to get as a retainer to work for someone who's got court coming?
How easy it is to get her employed.
Thanks. I'm not here to self-promote, you'll notice. I haven't even said the name of my firm or anything because I really am not into that. I've been asked for my business card. Really easy. Michael, Caroline, a few of the crew know how to find me. Sure.
the embassy have a good list of lawyers too.
Yeah, and Steve Bolt's great. He does heaps of work with the embassy. It's hard to go past Steve. Yeah.
With regards to the imminent peril, and the other one was
There's imminent, irreparable evil and imminent peril.
from my point of view, let's say your alternative is to use a pharmaceutical analgesic or anti-inflammatory. If you look at the actual pharmaceutical literature for each of those drugs, there is imminent peril and irreparable damage from taking those as an alternative. So couldn't you clear that?
Well, that's exactly why you'd have to run it all the way up to the Supreme Court
So
to
you're
try to have the
saying
test.
pharmaceutical drugs are evil while side effects. I'm just saying that for the audience to hear.
I don't think you'd get a bigger fan than Morgan Taylor over here to agree with you. Really, when she wrote the list of what she's been on, it was frightening. I mean, really life-changing stuff. So there's certainly an argument there, but current law? No, I can't imagine the local court magistrate would say, well, the fact that you don't like, well, maybe they would, maybe it's worth trying. I mean, I still wonder whether or not we should have pled not guilty in Steve Taylor's case and run it up the flagpole, because there was, some of those elements could be established, though it was a pretty hard sell in the sense that the fact that there were legitimate pharmaceuticals available that were lawful, and she chose not to take them and to instead consume juiced cannabis leaves. You know, therein lies a very strong prosecution argument against what you're saying about a lack of options and the imminent peril, you know.
Even though the pharmaceutical companies themselves have listed the side effects, the adverse side effects.
I'm not disagreeing with you. I'm saying I'd love to run up a flagpole. I'd love to, right? I'd love to. Get out of the way. I couldn't wait to be involved in taking one of the right matter all the way through and having necessity as it's strictly defined mellowed a little bit for medical necessity, and in this instance, medical necessity where cannabis use is the offence. But we're just not there yet, and the right case hasn't come and the right circumstances haven't. You'll see Lee Donnellan in that movie, High as Mike. I mean, I'd love to talk about that, but we're just right in the middle of it and I can't. But the level of outrage I feel, I honestly almost tear up at how awful he's been treated with his PTSD, and then a recent raid the police did, even though he's a lawfully prescribed user. I mean, it's just awful what that man's gone through. And he's in that High as Mike movie. Check that out tonight, because watch this space. I hope there's some good news coming out of that. We're hoping that the police will get some common sense, and we certainly ask them to.
Lady, question?
What happens then if you've actually, is it a viable case to go for the person who, or the perpetrator who was taking medicinal marijuana had actually experienced the pharmaceuticals and had been on those for some time and was changing and looking at doing, and had actually decreased and can prove that they decreased the amount of opioids that the doctors were giving them, and were using CBD only medication, that actually the person was able to pretty much get off all but one.
So the
of
question
opioids.
is...
So is that a viable, you know how you were saying about...
Is that a viable defence that a person's using CBD to alleviate their symptoms?
Well, it's the fact that they've actually tried and have been
And have
on
tried
opioids
pharmacy.
for a long time, and had then looked at it and decided to try something else, because opioids are going to kill them. There is no
Did
doubt
everyone
there.
hear that, roughly? Yep, okay.
So yeah, is that a viable thing if you can actually prove that for a court case that you have actually trialled opioids?
I wish I could say yes, but unfortunately we're back to the current test about irreparable evil and imminent peril. I'm sorry, but that's just where we're at right now in order to establish that you committed an offence out of necessity. So, you know, yes, and opioids, again, Lee Donnellan's thing tonight, you'll see that. Morgan Taylor, some of the symptoms. I mean, Morgan had to be hospitalised because of some of the side effects. of the pharmaceuticals.
What's happened with Morgan's case is the question.
Well, Morgan's going to speak to you very soon, so can I let Morgan answer that for you? So the final thing I thought I'd do, if I've got time, is just one quick mop-up that I thought people might be wondering about. You'll notice on May 20, the MDT laws changed so that for first offenders, you're getting an automatic $561 fine. You're being taken off the road for 24 hours. Your test results are going down to FAS, a forensic analysis in Sydney. They're coming back about 6 to 8 weeks later, and you're being taken off the road for 3 months. Suspension in New South Wales. Okay? So from 20th of May, $561 fine, 24 hours off the road, till the results come back from FAS, then they're going to take you off the road for 3 months. Which is how we haven't had that regime until the 20th of May. Everybody so far has been getting a court attendance notice and going off to court. Well, now you're getting this automatic fine and automatic suspension. The one thing I wanted to say was to anticipate possible questions. Yes, you can appeal that to the local court. And yes, if you're somebody who has, I'll just use myself as an example, has got a fairly clean, unblemished criminal history, fairly good traffic history, I would certainly be doing it. So if I got pulled over for a mobile drug test, positive, got my fine, got my 3 month suspension, and I put it on my hand appeal. The drag of it is that unlike some, I promise I'll stop now, but the drag is that unlike some appeals, licence suspension appeals, so if your licence is suspended in some instances, when you lodge an appeal, that stays the suspension. So you can keep driving until the appeal's heard. This isn't one of those.
Right. So, Sally, 2 quick questions, because I got the mic, I can sneak in here. 2 quick questions on this subject. If I have a legal prescription, can I get out of that? Like, look, I'm medically being treated, I've got a legal prescription.
From the mobile drug testing? No.
From this new
in
law?
fact, it may even work against you. So to put a prosecutor's head on my shoulders now, if I was a prosecutor, I'd say, wait a second, you actually knew that you could have THC in your system and you still chose to drive.
Yeah, well, I've got methadone and that's legal, and I can drive.
Oh, look, I know, you could shoot up heroin and,
Yeah, so what's the problem?
wash down half a dozen, codeines with a nip of vodka and drive straight through the mobile drug test.
Well, if
It'd be
it's
fine.
legal, it's legal.
Yeah.
So they don't make,
If you have THC, if you have THC in an oral fluid sample, whether it's from a medical use or not, you are still committing an offence if you drive. Legal medical cannabis. You wanted to ask?
I can guarantee you all illegal medical cannabis you're not allowed to drive.
Yeah.
The question is, what does the case look like you would like to take in the Supreme Court?
That's a great question, because I haven't had it yet. You can see it makes me smile. The question was exactly what does the case look like that I would like to run up the flagpole for a medical necessity defence. It does come pretty close to Morgan's. Probably if you, this is just like a really merciless, heartless thing to say, but probably if you had somebody who was actually about to die without ingesting cannabis, and that might be because they'd come off some meds and they were solely using medicinal cannabis, so they'd moved away from pharmaceuticals and now relying on medicinal cannabis, and if they didn't ingest it, they were a candidate for dying from some symptom that they were suffering from that medical cannabis could fix. That would be... Get out of the way.
The catch for me with that is you're not helping 99% of people. So there's all these little technical things you might get off on, passive smoking here or there, but the law is the crime really in it all. And we're not dealing with that bottom line. So next Friday I pleaded not guilty to my saliva test, and we're challenging next Friday in Ballina Court that the police are not administering the law according to what was intended. So I expect to bring down the entire government next Friday. Good.
how was it attended?
It's just stabbing in the dark. Hey, thanks Sally very much for being here.